Good afternoon, everyone, and welcome to the Consumer Affairs and Outreach Division's quarterly webinar on consumer protection issues. My name is Kayla Hernandez Ulloa, and I am Acting Chief of the Consumer Affairs and Outreach Division, which we like to call CAOD for short. If you're not familiar with CAOD, it is the Federal Communication Commission's division that engages the public through outreach and education initiatives to inform them about important consumer-related regulatory programs, telecommunication issues, and other consumer issues that affect their day-to-day life. This is also the first in what will be a series of quarterly meetings, which we will advise on as we have information available to us. Some housekeeping rules before I introduce our first speaker. In the interest of time, all speaker introductions will be brief. In the slide deck that we will share after the presentation, the speaker files are included, so you can read at your leisure when you get them. Again, copy of slides will be shared with registered individuals after the webinar. The questions for the presenters will be asked after all the presentations are finished. For those joining us right now, if you have your video and cameras on, please turn them off to allow for each speaker to present. This webinar is being recorded today, and we will advise when the video is available for your viewing. Our first speaker today will be Ed Bartholomew, who is the Bureau Chief of the Consumer and Governmental Affairs Bureau. In this role, he leads CGB's efforts to ensure the Commission meaningfully engages with external stakeholders, including state, local, and tribal governments, and the general public. And he oversees the Bureau's work to implement consumer policies, including those related to disability access. Ed's full bio is also included in the biography section of the presentation and is also available on FCC's website, fcc.gov. Now I turn over to Ed.
Thanks, Kayla. I'm excited to be here with everyone today, and I'd like to welcome you on behalf of the Commission to today's webinar. As Kayla mentioned, I do have the privilege of leading the FCC's Consumer and Governmental Affairs Bureau, and as she noted, we develop and implement the FCC's consumer policy and serve as the agency's connection to the American consumer. Our mission includes disability rights, consumer education, and outreach to state, local, and tribal governments. The Bureau also houses the FCC's consumer complaints team and our hosts today from our division that focuses on outreach and external engagement with the public. The FCC, or the Federal Communications Commission, regulates interstate and international communications by radio, television, wire, satellite, and cable in all 50 states, the District of Columbia, and U.S. territories. This encompasses licensing, spectrum allocation, enforcing communications laws, and promoting competition and innovation in the telecommunications sector. The FCC also regulates and oversees various areas such as broadband internet access, broadcasting, telephone services, and emerging technologies. Before we get to today's agenda, I wanted to share a few updates about the Chairman Carr's priorities here at the Commission. Earlier this summer, the Chairman announced a plan focused on building a stronger and more connected America. The Build America agenda will focus on delivering several core objectives, including facilitating high-speed infrastructure builds, restoring leadership in wireless technology, boosting the U.S. space economy, advancing national security, and strengthening the telecom workforce. These goals will be achieved by implementing smart policies and pursuing a comprehensive deregulatory agenda. In addition to focusing the Commission's work on Build America, the Chairman has also made clear that protecting consumers remains a top priority for the FCC. Today, you'll hear from my colleagues on some of the key consumer protection and public safety initiatives we've been working on. Before handing the event over to our first presenter, I wanted to highlight our top consumer protection priority, Stopping scam robocalls from defrauding American consumers. Earlier this month, at the first meeting of our Consumer Protection and Accessibility Advisory Committee, the chairman laid out our plan to work on stopping scam calls at each stage of the call's path, blocking more illegal calls before they ever reach consumers, and empowering consumers to make more informed choices about answering calls when their phones do ring. More to come, and I look forward to sharing future updates on our work to protect consumers. Finally, I'd like to share my thanks with the FCC speakers presenting today, our hosts and organizers in our outreach division, and to all of you for taking the time to attend and learn more about the FCC's important work protecting American consumers. And with that, I'll turn it over to Wes.
Thanks, Ed. And thank you, Kayla and team, for putting this together, and everyone who's on the line for joining us today. I'm here to talk to you about the slamming and truth in billing notice of proposed rulemaking that the Commission released in July. In this document, the Commission jumpstarts an effort to modernize and streamline these rules. And this effort is inspired by a desire to, catch up with the evolving telecommunications marketplace and the telecommunications industry as a whole. The proceeding will explore ways to reduce regulatory burdens while retaining core consumer protections where they're needed. In particular, this Notice of Proposed Rulemaking, or NPRM for short, seeks comment broadly on whether slamming and bill confusion remain significant consumer problems in light of marketplace changes since the Commission adopted these rules decades ago. And if they do remain problems, the Commission proposes to change them in ways that I'll cover over the next few slides. So slamming is the illegal practice of changing a customer's wireline telephone service provider or submitting a request to do the same without their permission. Today's consumer typically subscribes to a single service that includes both local and long distance, often for a set monthly price. And in large part because this change in technology and also the change in consumer preference, the FCC has not received any recent complaints that describe the slam. And this is in stark contrast to a decade or two ago, where we used to receive thousands of slamming complaints. And if you look at our enforcement actions, these also suggest that slamming is not the problem that it once was. In fact, the last one that we took was over 7 years ago. And moving on to truth in billing, these rules reflect an era where it was common for people to look at their telephone bills and see those different add-ons for things like call waiting or call forwarding or three-way calling, with each of these showing up as a line item on the bill. However, most phone services today include these features at no additional cost. And beyond this, as smartphone use has grown, third-party charges have moved. Now they're not usually on your phone bill, they're in your App Store purchases. And similar to slamming, the FCC hasn't adopted a forfeiture order for a truth in billing violation since 2016. And even that was based on activity that occurred in 2013, more than a decade ago. So if the record that we receive in response to this NPRM indicates that slamming and bill confusion remain problems, the NPRM proposes to unify those rules into a single rule section to make it easier for consumers to understand the rules and for providers to comply with them. The NPRM also proposes to replace some of the detailed slamming rules with a single simple requirement that both protects consumers and gives providers flexibility in how they demonstrate that they've obtained a consumer's authorization. In addition, the NPRM proposes to modernize the truth in billing rules by eliminating the requirement to display separate sections on bills for third-party charges and the requirement to display a toll-free number for customer service on each paper bill. The proceeding is open. Comments are due September 22nd. Reply comments are due October 21st, and we are keeping track of what's filed and look forward to learning more about the state of affairs and what folks think about our proposals, and encourage any and all feedback on these things. And with that, I'll turn it over to James to talk about the missing and endangered persons emergency alert code.
Thanks, Wesley. Can everybody hear me okay? It looks like the microphone input is coming through on my end, so barring any objection, I'm just going to proceed.
We can hear you loud and clear.
Wonderful. Thanks. Well, it's a pleasure to have the opportunity to speak with you all today. My name is James Wiley. I'm Deputy Chief in the Public Safety and Homeland Security Bureau's Cybersecurity and Communications Reliability Division. And the topic that I'd like to discuss with you today is a new kind of emergency alert. Next slide, please. So many of you have probably had the experience of receiving an emergency alert, whether that be through hearing the distinctive audio attention signal come over your radio or television set, or hearing the same come over your mobile device. Most people have had the experience of hearing this attention-grabbing signal that indicates that you've received an emergency alert that's intended for you. I'd like to speak a bit as a preface to introducing this new code about the two different kinds of emergency alerting platforms that are available and the differences between them, so that you can have a better understanding from the alert originator's standpoint about considerations that attend the use of each system. The first system that I'll talk about is the emergency alert system. And that is the legacy system that's been around since the World War II era and is participated in on a mandatory basis by all broadcasters, cable operators, satellite providers, and others to provide both visual and audio alerts over a variety of devices. EAS messages are up to 1,800 characters long that will scroll across the bottom of your screen or be presented as a block text on a full screen replacement. And the audio is up to 2 minutes in length, often a pre-recorded audio that is intended to motivate protective actions for alert recipients. From the alert originator standpoint, what's critical to understand about EAS is that while participation in the system is mandatory for the Commission's regulatees, each regulatee has discretion to choose which specific types of alerts they will retransmit to their communities. So as I'll get into in further detail with respect to this new code, if you're interested in receiving alerts of this type, you really need to go and engage with your local broadcasters and cable operators to advocate for them transmitting these alerts to your communities. The second kind of alert that is part of this National Public Alert and Warning System is wireless emergency alerts, or WEA. WEA alerts are delivered to mobile devices, primarily cell phones. All modern smartphones really support WEA. And there, what you'll see is text-based messages up to 360 characters in length. And they are about basically the same subject matter as EAS alerts, but the codification of the kinds of alerts that are eligible for transmission over WEA is just distinct from that which pertains to EAS. Another distinction between WEA and EAS is that whereas participation on the part of EAS on the part of broadcasters, cable operators is mandatory, wireless providers' participation in WEA is voluntary. However, if a wireless provider voluntarily elects to participate in WEA, then it becomes mandatory for them to do so in a manner that complies with all of the Commission's rules, including the transmission of all eligible alerts. So, whereas each individual EAS participant is going to have discretion about whether to transmit EAS alerts or not, that is not the case for WEA. All WEA participants must transmit WEA alerts. Next slide, please. So, what's new here? What's new here is, as of September 8th, 2025, alert originators can now send a new kind of emergency alert. It is the Missing and Endangered Persons Code. This is a code that corresponds to the issuance of alerts about all different types of missing people that have not heretofore been eligible for an emergency alert when they go missing. Amber Alerts. Many of you have heard of Amber Alerts. Likely you've received an Amber Alert that seeks to elicit your assistance to law enforcement in the search for a missing child. What this MEP code does is it augments the scope of emergency alerts eligible for issuance over EAS and WEA to include not just children that are missing and endangered, but also adults. And advocacy to the FCC for the adoption of this code was really championed by groups across the country looking to use these emergency alert systems to get the word out about missing and endangered Indigenous people in their communities. There are programs throughout the country for like turquoise alerts or feather alerts that all go towards making it particularly likely that people who are missing in our Indigenous communities are able to be brought home to safety. And this new code is intended to facilitate those efforts, make it easier for them to advocate with EAS participants for the transmission of those alerts to their communities, because there is a code specific to this type of alert for them to issue. And we're hopeful to see a quick uptake in the transmission of this alert type among EAS participants. Next slide, please. So I've outlined what the MEP EAS code does. What I'd like to focus on with this slide is what it is not. It is not a new alert and warning system, particularly for identifying missing adults or missing Indigenous people. The MEP EAS event code is simply a means of activating existing systems. Next alert, please. Sorry, next slide. I've touched on this as well, but the point of the EAS MEP event code that I'd really like to hit home on this slide is that EAS participants are not under an obligation to carry this type of alert. So if this is of interest to you, if this is a type of emergency alert that you think is important for your community to receive, it's voluntary for EAS participants to carry them. The onus is on the public, is on alert originators to let their broadcasters, cable providers know that this is of interest to them. These are kind of messages that they want to receive and to have them enable the retransmission of those alerts through their EAS equipment. Next slide. I believe that could be the end of the presentation. It is. So, so with that, I'd like to introduce my friend and colleague, Brenda Boykin, from our sister division in PSHSB. She is the Deputy Chief at the Policy and Licensing Division there. Brenda?
James, just want to check, can everybody hear me?
Loud and clear.
Okay, great. Thank you. As James said, I'm Brenda Boykin, and I'm a Deputy Chief in the Policy and Licensing Division of the FCC's Public Safety and Homeland Security Bureau. Today, I'd like to provide you with an update on the Commission's rules for calling 911 from multi-line telephone systems, or MLTS. Next slide, please. MLTS are the telephone systems with multiple phones or extensions that are installed in office buildings, schools and college campuses, hotels, and similar environments to serve employees, residents, customers, students, and guests. An office-based MLTS typically allows employees to communicate with their coworkers, while a hotel-based system allows hotel guests to call other guests or hotel staff. In addition, MLTS systems allow users to make calls to outside telephone numbers, including emergency calls to 911, and that's where the FCC's rules come in. The Commission's rules for MLTS arose out of a terrible tragedy. In 2013, Carrie Hunt was killed by her estranged husband in a motel room in Marshall, Texas. Ms. Hunt's 9-year-old daughter tried multiple times to call 911 from the motel room phone, but the call didn't go through because she didn't realize that the motel phone system required her to dial 9 first to obtain an outbound line. And this terrible event shows how vitally important it is that anyone using an MLTS to call 911 can actually reach 911. So Congress responded to this tragedy by enacting Carrie's Law, which is named in honor of Ms. Hunt, and which requires direct dialing and notification capabilities for MLTS. Congress also enacted Section 506 of Ray Baum's Act, which directed the FCC to consider adopting rules with respect to caller location information that must be conveyed with 911 calls, including calls from MLTS. Next slide, please. In 2019, the FCC adopted rules implementing both of these statutes. Under these rules, MLTS managers, operators, and installers must ensure that the MLTS allows direct dialing of 911 without requiring the caller to dial an additional number, such as 9, provides notification to a central location, such as a building security desk or a hotel front desk, that a 911 call has been made from the facility, and provides some information about the caller's location along with the 911 call. And there also are rules that apply to MLTS manufacturers, importers, sellers, and lessors. There is an important exception to these requirements, though. The statutes and the rules that the Commission adopted do not apply to any MLTS that was installed on or before February 16, 2020. However, if a business upgrades one of these older MLTS systems after February 16, 2020, then depending on the magnitude of the upgrade, the MLTS may become subject to the rules. So this exception covers a diminishing number of these multi-line telephone systems, because as businesses install new systems and upgrade older ones over time, the number of these systems that are exempt because they have this grandfathered or legacy status is getting smaller and smaller. Next slide, please. The MLTS rules apply to people and entities that the FCC traditionally doesn't regulate, such as hotel managers or people who manage a business office. These are people who, traditionally haven't had, for example, a license with the FCC. And in addition, it has been more than 16 years, not 16, 6 years since the adoption of these rules. And as a result, some of the people who need to know about these rules may not be aware of them. And so for that reason, the FCC is launching a renewed initiative to raise awareness and improve compliance with these important rules. Next slide. A key aspect of the outreach initiative is a new fact sheet we've created for MLTS managers, operators, and installers. The fact sheet explains the rules, why they're important, and where to go for additional information from the FCC. It also has a decision tree that helps the reader figure out whether they could be subject to the rules. So it helps you read through the tree and determine if you may fall within the exemption, or if you don't and may be subject to these requirements. The fact sheet is available on our MLTS webpage, and it also has a QR code on the first page that will let you download it to your phone. Our MLTS webpage also includes other resources, such as a Q&A document, a timeline, things like that provide guidance on these rules. Next slide. This next slide has some information on how to file a complaint with the FCC arising out of the MLTS rules. We closely monitor any complaints we receive alleging violations of these 911 rules. And finally, we'll be speaking on this topic to other groups whenever we have the opportunity to do so, and we'll be sending out the fact sheet through some of the FCC's email outreach lists. We also really appreciate the opportunity to speak to you today, and we'd like to ask you to help us with this outreach by downloading the fact sheet and sharing it with others who could benefit from this information. And of course, please reach out to us if you have any questions. Thank you. Our next presenter will be Christy, who is going to talk about the Safe Connections Act. So Christy, over to you.
Thanks so much. I appreciate it. It's a pleasure to be here with you today to talk about the Safe Connections Act. And I'll go to our first slide to explain why the Safe Connection Act is important. So Safe Connection Act is about domestic violence. So when an abusive partner shares a multi-line plan, such as a family plan, they're able to do things like monitor a survivor's calls and text messages, and also know the precise location of the device that the survivor is using. So for survivors who want to leave their abusive partner but keep their phone number, line separation has often been a challenge. Think about how many ways and how many people have your cell phone number, usually for banking and for doctor's appointments, doctor's offices, school closings, things like that. It can be really important to keep that number. And yet, if you're in a domestic violence situation and trying to leave that, the ability to take that number with you without others knowing is really important. The Safe Connection Act, which was enacted by Congress in November 2022, makes this process easier and more accessible for survivors. It ensures that those survivors of domestic violence and also other types of abuse are able to establish independence from abusers without losing access to that telephone number. In response to the Safe Connections Act, the Commission in November 2023 adopted rules to implement these provisions. And the rules largely track the statutory language, but there are some key additions and clarifications for privacy, for account security, fraud detection, and also technical feasibility for providers. The compliance with these line separation rules was required very recently in July 15th, 2020. I'm sorry, not recently, 2024. So let's look at those a little bit more, please. Next slide. So the rules require a few things. Primarily, it requires that mobile service providers separate the phone line of a domestic violence survivor and any lines associated with individuals in their care. So a minor child, an elderly person who you may support financially or live in your household. It requires that mobile service providers separate those phones lines from the shared account with an abusive partner, usually within 2 days of receiving a valid request from the survivor. There can be exceptions to that, but generally within 2 days. The requirements for survivors to make a line separation request are the same regardless of who your mobile service provider is. And I've listed those 5 requirements here. So stating that the survivor is requesting relief from a provider under the Safe Connections Act. We found that it's really important for survivors to say, I'm actually making a request under the Safe Connection Act, and then it clears up any ambiguity. Then you have to identify each phone line that should be separated from the account. You have to submit an affidavit of for an individual in your care if you're acting on their behalf. And then you need to identify which phone line is the abusive partners that needs to be separated. You also need to submit documentation that you as the survivor are covered under the act, such as you're a victim of domestic violence or dating violence. Next slide, please. The documents that you must submit are actually, it's a pretty extensive list, and providers are required to consider those even if they are expired documents. So if you had a protective order that expired 6 months ago, providers are still required to consider that. You only need one of these types of documentation, but there is such a variety. I wanted to go over these. One of those would be a signed affidavit from a licensed medical provider or your mental health care provider, a social worker, or a victim service provider, or even a court employee associated with the proceedings. You could also provide a police report, police statements, and that can include military or tribal police. Those statements from magistrates or judges, charging documents, protective or restraining orders, or any other type of official record. You'll notice also that military protective orders and documents from a licensed military care provider isn't included on this list. And if you're making a request for someone in your care, again, that minor child type of situation, you need an affidavit signed by you stating that they are in your care, identifying the line, and dated near the time of the request. So you'll see a lot of different types of documents. The commission wanted to make this as practical for survivors to use as possible. Next slide, please. The Commission's rules also include provisions for privacy of the survivor. And I will note at the beginning, the very last bullet here, which says this portion of these rules are not effective yet. So while the previous rules I discussed are effective, these have not become effective yet, but I wanted to let you know about them so you can know what's coming. The Commission's rules require wireless providers to take measures to protect the privacy and safety of survivors. Creating a new account keeps your new information confidential from the abusive partner that you formerly shared an account with. But you also want to protect other privacy aspects. So the privacy of calls and texts to hotlines. Those have to be, the next 2 bullets, omitted from consumer-facing logs of calls and text messages. Any records of calls or text message to covered hotlines in a database that the Commission will establish. And then also maintaining internal records of calls and text message that are excluded from consumer-facing logs or calls and text messages. So for instance, if you have a cell phone bill that still lists all of the numbers that you have called, those types of things would have to be removed before the bill is printed. Next slide, please. The rules also provide financial assistance for certain domestic violence survivors requesting a line separation under the Safe Connection Act. So if you're familiar with the Lifeline program, there's now a way for Safe Connection Act applicants to receive Lifeline benefits. So it can be up to 6 months of benefits for separation requesters who are facing financial hardship. And those criteria are specific to the Lifeline program. So I'm not going to speak to those, just wanted to let you know that those exist. And then final slide. You will notice that we've listed here the information for the National Domestic Violence Hotline. The Commission is working with National Domestic Violence Hotline to make sure that survivors are aware of this program, and also so that we at the Commission can refer people to National Domestic Violence Hotline as needed. Just wanted to let you know those are there. Next month is National Domestic Violence Awareness Month. October is, and the Commission is producing an updated consumer-facing webpage with more specific information on the Safe Connections Act, and we look forward to making that available for you. And with that, I will turn it back over to Kayla.
Thank you. So now we're at the part of the program that a lot of you were waiting for. We are going to go into questions from the audience. My colleague David Perez will be helping me with that. So David, do we have any questions for our speakers?
I do have a couple questions here I can read for you, Kayla. And if folks online have additional questions, just drop them in the Q&A box. Thank you so much. The first question says, what do I need to make sure that people in my community can receive missing endangered persons alerts?
I believe that question may be best answered by James. I do not hear James, so I guess, David, we can go to our next question.
Sounds good. Okay, the next question we have on deck says, is it still possible that callers will need to dial 9 first before calling 911 from a multi-line telephone system?
Hold on, yeah. I don't know if you all can see me, but that is still possible. It's still possible for there to be these phone systems where you do have to dial 9, and at least under our rules, that would be allowable. And the reason is because of that exemption that I mentioned for these older so-called legacy systems. If the system was installed on or before February 16 of 2020, then it is not required to comply with the FCC's requirements unless it undergoes an upgrade after that date. But as I also mentioned, the number of these legacy MLTS systems should be getting smaller and smaller as people install new systems and upgrade older ones. And it's also possible that the state does not recognize this exemption. For example, Massachusetts doesn't recognize an exception to the MLTS rules for older systems. So in Massachusetts, you shouldn't, generally shouldn't see any of these systems where you have to dial 9 first. The Public Safety Bureau of the FCC strongly encourages enterprises that have one of these legacy systems to put the instructions for dialing 911, somewhere prominently near the phone, like on a card or tag, so people realize that they have to dial 9 or whatever else they have to do. But again, if it's subject to our rules, a card like that is not enough. You have to be able to just dial directly.
So much. We appreciate that answer, Brenda. Again, additional questions from the attendees, just please drop them in the Q&A box. There is a little icon in chat there where you can drop them in. I have one more additional question at this time. It says, do the Commission's rules require hotels, business offices, or other enterprises to have a multi-line telephone system?
So we have received this question, a number of times. In one instance, from a hotel that was in under planning. It hadn't been built yet, and our federal MLTS rules do not require that you include an MLTS. You don't. They don't go to that. But if the enterprise has one, then our rules would apply and would say that you've got to have this direct dialing, you've got to provide central notification, and you've got to convey some information about the caller's location with the call, unless, of course, the MLTS falls within that exception because it's pre-February 2020. But we do recommend that enterprises check whether there are any other legal requirements that may say, for example, that you do have to provide a phone system in a certain type of enterprise. So.
Thank you so much, Brenda, for answering that. Kayla, at this time, I don't have any more questions from the attendees.
Thank you, David, and thank you for everyone who submitted questions to our speakers. We now move to the next part of the webinar, which will be kind of a summary provided by CAOD of things we think might be of interest to attendees here. Please share this information widely within your networks. The first is we now have information about the top 5 robocall scam complaints reported to the FCC in the month of August. It's now available on our website. These include scams about loans, insurance, especially health insurance, government imposters pretending to be people from the IRS or Treasury, scams related to credit or credit cards, and this is a new one for me, but there's a lot of scams related to solar and energy related type of scams. This being September, it is National Suicide Prevention Month. Visit the FCC's webpage, 988 Suicide and Crisis Lifeline, for more information. And I'll stop here and say all the topics you see here, we do have links in the resources portion of the slide deck for viewing later. Continuing on September 10th, the FCC released a consumer advisory alerting the public about scammers who leave an urgent message to call them back immediately. This is related to information that's left in their message where scammers are offering discounted cable and streaming services at a 50% discount, letting consumers know that this is a discount on their monthly bill that is set to expire. Next, we wanted to give just a little bit more information about the FCC's next open meeting. This is scheduled for Tuesday, September 30th. It starts at 10:30 a.m. Eastern. Topics mentioned in the draft agenda include accelerating wireline infrastructure build-out, freeing wireless infrastructure from unlawful regulatory burdens, phone jamming solutions in non-federal correctional facilities, modernizing broadcast ownership rules, and also the deleting obsolete and duplicate wireline rules. In the links that are provided in the resources section, you'll find more information, including all the docket numbers for the information that is on the agenda. I wanted to remind everyone here that if you're not available to attend the FCC's open meeting on September 30th in person at headquarters, you may also watch the live stream that's going to be available on fcc.gov/live. The meeting is also archived for viewing at a later date. The FCC is also seeking comments on alert transmission capabilities that can promote flexibility and consumer choice by allowing for greater tailoring as to how alerts are received and presented on various devices. This includes things like language, location, screen placement, font size, text-to-speech, and other accessibility options. The Notice of Proposed Rulemaking, NPRM for short, seeks to re-examine the emergency alert system and the wireless emergency alerts, which we had a great presentation on earlier, from the ground up and explore whether fundamental changes could make these life-saving systems more effective, efficient, and better able to serve the public's needs. Comments are due on or before September 25th, 2025, and reply comments are due on or before October 10th, 2025. In the resources section, we have information about the FCC's electronic comment filing system, also known as ECFS, and a consumer guide on how to file comments on this and previously mentioned windows for comments and reply comments. Though this is not for this month, next month, October, will be the 15th anniversary of the 21st Century Communications and Video Accessibility Act. This is going to take place, the anniversary, on Wednesday, October 8th of 2025. To learn more about this act, called CVAA for short, visit the FCC's website on CVAA. If you're new to CAOD's events and receive this information from a friend or a colleague and you want to be added to our email list, please send an email to outreach@fcc.gov. That's also the email that we use to send out our invitations to events, any updates from the commission, and much more. Our next webinar is going to take place in December, so you have plenty of time to register to be on our contacts list. And as on the screen, we have the list of resources that are available. So as we come to a close for this webinar, I'd like to thank everyone for their help, especially our speakers, Ed, James, Wes, Brenda, and Christy. And I'd also like to thank my team for their help with putting together this webinar that includes Sherry Dawson, Alma Hughes, Deandra Wilson, David Perez, David Savaline, and Kimberly Marshall. And of course, our interpreting team. Speaker bios, again, are going to be made available at the end of the presentation slide deck, and we will be sharing this soon after the webinar. So with that, I'd like to thank everyone and wish you a great day. Please remember to contact outreach@fcc.gov with any questions or for additional information. Thank you.